I invite Advocate C. Unnikrishnan, the Secretary of ILU High Court Unit, to deliver the welcome speech.
The President of the President of today's function, Sri Professor M. Sridhar, Sri Senior Advocate Sri P.V. Surendranath, Advocate C.P. Pramod, all other dear friends. All India Lawyers Union is an organization of lawyers, law teachers, and law students. It is the largest organization amongst the lawyer community of India, having its roots in 26 states. As an organization which is committed to uphold the constitution and also the laws, and to make the people aware of the constitutional as well as other rights, All India Lawyers Union is indulging in conducting discussions on important issues which involves legal as well as social and political problems. It was in the above attempt that High Court Committee of All India Lawyers Union thought it fit to organize this webinar on the subject, which has assumed importance currently due to the so-called misuse of powers by the persons holding the post of governor with some political motives. The Constitution of India, having provided a parliamentary form of government in the state as well as in the center, the governor has to be considered only as an eminent executive, not the real executive. The real executive being the Council of Ministers headed by the Chief Minister, and the governor is supposed to exercise his powers and functions with the aid and advice of the Council of Ministers headed by the Chief Minister, probably except in a few matters in which he is required to act and apply his judicious discretion. It must have been the precise reason as to why the framers of Constitution of India had rejected the idea of an elected governor, because it was clear to them that political power should only be vested with the elected executives. As expressed by the great constitutional expert Sri Nani A. Palkhiwala, the Constitution intended that governors should be instrumental to maintain the fundamental equilibrium of people of the state and to ensure that mandates of the Constitution are respected in the state. Dr. B.R. Ambedkar was also very sure that the governor should use his discretion not as a representative of the party, but as a representative of the people as a whole. Along with All India Lawyers Union, I would like to believe that governor is expected to advance the cause of federalism and democracy in the contemporary constitutional landscape, which form a part of the basic structure of the Constitution. In this point of time, it is relevant to point out Justice Punji Commission, which suggested the phrase, during the pleasure of the president, should be deleted from the Constitution, because a governor should not be removed at the will of the central government. Instead, he or she should be removed only by a resolution of the state legislature. Unfortunately, there is no provision for, at the same time, there is no provision for impeachment of governor, unlike in the case of President of India or judges of the Supreme Court and High Court or Chief Election Commission. Reading of Articles 156 and 74 of the Constitution of India tends one to believe that it is the ruling party of center which appoints or removes the governor, which is not correct. We are very fortunate to have three eminent speakers today who can speak elaborately on this subject. First of all, for the sake of formality, I invite Sri C.M. Nasser, the State Committee member of All India Lawyers Union, who is presiding this function. And on behalf of the High Court Committee of All India Lawyers Union, I extend to him a warm welcome. The next person is our General Secretary and Senior Advocate, Mr. Sri P.V. Surendranath. It is only in this, for the sake of formality, I am inviting him because he is one amongst us, and he is part and parcel of this organization. On behalf of High Court Committee of All India Lawyers Union, I extend a warm welcome to Senior Advocate Sri P.V. Surendranath, who is the General Secretary of All India Lawyers Union. Next is our beloved chief guest of this evening, Sri M. Sridhar, who is now a dean of Mahindra University and who was formerly a professor, eminent professor of Nalsar University. Professor Sridhar was also a member of the Information Commission, where he did a commendable job. And as all of us know, he was instrumental for many historical decisions while he was holding that post. He has always associated with the work of All India Lawyers Union, and we cannot forget the tremendous service he has done, especially during the national conference held in Hyderabad. On behalf of the Lawyers High Court, on behalf of the High Court Lawyers Union of the High Court Committee, and on behalf of all of you, I extend to Sri M. Sridhar a warm welcome. Welcome to the webinar, sir. Now, I have to invite Sri C.P. Pramod. As I have suggested in the case of Sri P.V. Surendranath, Mr. Pramod, Comrade Pramod, C.P. Pramod is our state secretary, and he is giving us all types of guidance, and wherever it is necessary, he is guiding us in the right direction. In the name, for the sake of formality, I invite Sri C.P. Pramod, State Secretary, Advocate C.P. Pramod, to this function on behalf of the High Court Committee of All India Lawyers Union. A warm welcome to you, Comrade C.P. Pramod. Now we have several of our national leaders, Mr. Thomas Abraham, Advocate Thomas Abraham, Advocate K.K. Nasser, Advocate N.C. Mohanan, Advocate Leda Tangappan, Sri Rao from Hyderabad, and Mr. N. Manoj, who is also the State Attorney of the State of Kerala, Sri Ashokam Cherian, who is also the Additional Advocate General of Kerala State. I welcome each of them in my personal behalf and on behalf of the committee, High Court Committee of All India Lawyers Union. I also welcome all leaders of the state leaders and High Court Committee members of All India Lawyers Union to this function. A warm welcome to all. Good evening and thank you.
The respected dignitaries and dear friends and comrades, today we are discussing an important topic on role of governors and the federal system of governance. Our constitutional provisions envisage the governor must be a friend, a philosopher, and a guide to the government of the state to which he belongs as the governor. Unfortunately, some of the governors of the view that they are ruling the states. It is the confrontation of the elected government and the constitutional heads. It is not a new one. In the history, there are so many incidents there. Quite recent also, we can see several such incidents. In Maharashtra, I think it is in January, Maharashtra, the governor refused to accept the date fixed by the government for the election of the Speaker of the Legislative Assembly. And in Tamil Nadu last day, I think yesterday or day before, governor rejected a bill, returned the bill passed by the Legislative Assembly. I think it is in respect of NEET or something. And in Kerala also, Kerala, the confrontation in respect of an appointment, a reappointment of a vice chancellor. So, this confrontation is growing and it is a challenge to the constitutional provisions and the federal system of the governments So in this scenario, that the All India Lawyers Union High Court Committee organizing this webinar on such a topic. Today, we have seminar luminaries to speak on the issue. I invite Senior Advocate T.V. Surendranath to deliver introductory speech on the subject.
Surendra sir.
Hello, am I audible?
Yes,
Yes, sir. Yes, sir. You are audible.
Advocate CM Nasser, President of today's function. My dear friend, Professor Dr. Madhabu Sridhar, CP Pramod, Secretary of ILU Kerala State, Shri Sriuni Krishnan, Secretary of ILU High Court Unit, Additional Advocate General Ashokam Cherian, my dear friends. After a long time, we are interacting together, though not in physical mode, still we are face-to-face interacting. Thank you for this opportunity. Of course, All India Lawyers Union have been thinking of switching over to physical mode, all its meetings and functions. And at this time, of course, we have to keep that aside because the third wave is on. And Kerala, of course, is suffering a lot. Sorry. Dear friends, anyhow, we have to make available the present technology for all these purposes, and we have been doing that. Without elaborating on the subject, because for elaborating the subject, exposing its nitty-gritty from various angles, Dr. Madhabu Sridhar is here. I'm also waiting very eagerly. You know, All India Lawyers Union is concerned about keeping intact the basic structure and basic features of the Constitution. Whenever there is onslaught on the Constitution, whenever there is onslaught on its basic structure, basic features, it is secularism, whether it's federalism, whether it is fundamental freedom of free speech and expression, human liberty, human rights, All India Lawyers Union is in forefront, has been in forefront to fight against it. And necessarily, federalism is part of our basic structure and one of the basic features of the Constitution. We as an organization are concerned about democratization of the society, democratization of each and every constitutional institution and democratic institutions, and necessarily democratization of the office of the governor. Especially in the context of present tendencies all over India to arrogate to itself extra constitutional power, despite the fact that Constitution and the Supreme Court of India in various decisions delineated the powers of governor or the absence of power to the governor, absence of powers of the governor. Because during the constitution debate, clearly rejected the idea of an elected governor, the idea of giving any independent function or power to the governor with respect to administration. Of course, the formation of government is there, and 356 is there. That apart, that I am not dealing with. But as a dignified titular executive head of the state, no independent function or power is given to the governor by the Constitution, and that has been emphatically clarified by the Supreme Court in various decisions. But despite that, recently, we have been witnessing the tendencies to arrogate to itself the extra constitutional powers. And I think this is the context in which the High Court of the ILU High Court unit ventured for this program. Definitely the All India Law High Court Committee is to be congratulated for this intervention at the right moment, subject of topic interest. See, during the constitutional formation debate, there was a request or appeal for a governor to be elected by the people by way of direct election or otherwise. That is emphatically rejected. Similarly, there was demand for giving independent powers and functions for the governor. That was also rejected. I have already mentioned that. But the point is that despite all these clear delaying power or absence of power of the governor, now we witness various tendencies. And for this, one thing we have to mention, the recent tendencies of appointing governor, picking persons who have been indulging in party politics till the previous day. Such persons are airlifted and appointed as governor. The other day, the same person will be heading as secretary or president of another political party and indulging in all sort of petty party politics. So one of the reasons for this sort of tendencies is this. Nobody is now concerned about the concept evolved in the Constitution, how the concept of governor came into the Constitution as a dignified, politically neutral, executive head, a titular head. So definitely, I hope and I'm eagerly waiting to hear my dear friend, Dr. Sridhar, giving light on all these aspects. So once again, I congratulate the High Court Committee for organizing this function, and I offer my felicitation to this function. Thank you. Thank you.
Nasser, unmute Nasser, unmute.
Sir. Now I invite Professor Dr. M. Sridhar to deliver the inaugural address. Sir, please.
Good evening to all of you, sirs. It was a great introduction. I think you have set the agenda of the discussion by talking about the examples, recent examples of the governors in various states where other party is ruling, other than ruling party is ruling. And Sridharji also brought out very, very nascent points about the origin of the present day governorship. I do not know whether Constituent Assembly has really visualized the kind of governance we are seeing today. It's very surprising. Then Advocate C.M. Nasser also pointed out how the governance institution is behaving in a general manner as an agent of central government. Governor is not an agent of central government. Agent, to say somebody in such a big position as an agent of central government itself is an insult. And that should not have happened in any state. The governor is expected to be a statesman, a neutral person, apolitical, unbiased, do not carry the luggage of the political party from which he came, or he should not behave like a subordinate to the Home Minister. If a head of the state is subordinate to Union Home Minister, imagine the situation. How can it be a federal government? That itself is a ridiculous equation that Constitution has provided for. So my friend Uni Krishnan has taken a lot of trouble in organizing this, and he was talking to me very frequently. I postponed it because of COVID, and luckily we could assemble again. Thank you, all of you. And my friends from Hyderabad are also, many friends are also associated with this meeting. It's a great privilege, I deem it a privilege to talk about the constitutional position of a governor. In fact, there is a demand to remove the doctrine of pleasure theory, doctrine of pleasure. What a undemocratic expression that we have in Constitution, doctrine of pleasure. And one person who continues in power because of pleasure of another person, how can he be a democrat? The basic origin of the post of governor, a basic appointment in the post of governor has a conceptual deficiency. I look at it like that. So whose pleasure that matters in appointment of governor? Is it president? Will president appoint anybody? He will not appoint anybody, though his name is appended to in the appointment order. Then that means it's pleasure of prime minister. And what is the role of a prime minister in our democracy today? Prime minister is also a party president or very top personality of the party. Maybe you will find two persons as party leaders in present ruling disposition. That's a different thing. But they are one and the same. Though there is a different, he is a different personality, but he is part of the cabinet. The party president is part of the cabinet, and the prime minister is very close to him. That means it makes no difference. The multiplicity of personalities at various power centers is the theory of democracy. Internal theory of democracy or the democracy in the constitutional institutions. A political party basically is not a democratic party. How can it give a democratic administration when it is sitting in a constitutional position? Is a big question. Nobody bothers about it. We have to somehow come to power, appoint or see that our chief ministers are elected. If not possible, appoint our governors. Do you remember Kiran Bedi was contesting election in Delhi, and she was putting all her efforts, and BJP was in all totally supporting her. Several actors were involved, cabinet ministers were involved. Everybody thought that she gave either tough fight or she might even win. But Kejriwal has won, you know that. And do you know what happened immediately after that? The loss of Kiran Bedi in Delhi became a problem of what is that state? Pondicherry. Problem of Pondicherry. So this woman goes as there as a lieutenant governor. Unnikrishnan wanted me to talk about governors, but there are other creatures in the Constitution of India called lieutenant governors and administrators. They are very powerful. They are real rulers. And you know what was the statement against Nawab Jung, who was lieutenant governor in Delhi? He was harassing, at the behest of ruling party. He was harassing Arvind Kejriwal like anything. It's very, very difficult. Sometimes, we can't even bring in constitutional provisions to understand their behavior. Impossible. Then Unnikrishnan talked to me about the vice chancellors and the story of the chancellor. 2 vice chancellors of Kerala and 1 chancellor of Kerala, how the controversy was going on. I was really surprised. In an academic institution, can there be such a big controversy? What happens to academic independence? Forget about constitutional aspects and tussle between executive government and the chancellor or the governor of state. Forget about it for a while. What will happen to university? What will happen to the relationship between vice chancellor and students? I was surprised when governor stated that I hung my head in shame after reading the couple of sentences written by a vice chancellor. See, will you judge the capacity of a vice chancellor for his grammatic sentences or eligible, flowery language? Or do you need any other ability in that person? Okay, even if you have assumed that there are certain grammarian mistakes in the statement, he should have discussed it with vice chancellor or somebody else. Making it public, what will happen to the university? That was my worry, because I am from academics. I was really worried. If a student knows that his vice chancellor is certified by the chancellor, that he doesn't know how to write English, what will happen to him in the university? More than your constitutional question, I am worried about that. The entire value that you are supposed to give to the teacher and teacher appointee vice chancellor is gone. So this is a worrying factor. So it is not just the violation of or breaching constitutional norms and provisions. It is also bringing down the elegance and eminence of the position one is holding. That is a terrible thing I consider. And look at this doctrine of pleasure. Now, when does pleasure come and when does pleasure go? See, we have a general expression in English, whims and fancies. One ruler should not rule according to his whims and fancies. And if a constitution provides for whims and fancies, where is the system then? We have to suffer the accidental good character of the prime minister or president, or accidental bad character of prime minister or president. If the administration is left to the whims and fancies of the rulers, how can anybody say that it is a constitutional governance? This is a basic question we have to. And I would like to point out another anomaly in the system of governance, very interesting anomaly, pointed out succinctly by Surendranath Garu and Nazar. See, he doesn't have any constitutional duty. Very interesting point. But he is the head of the state. The huge power is given to him without a corresponding responsibility to perform. He's a reporter. He's something like a Indian Express reporter in what is it? What is your capital? Thiruvananthapuram. Like Indian Express reporter in Thiruvananthapuram, special correspondent. He will be writing to the central government. He will be giving reports. And if one of the reports is, if it is an unfortunate situation for the chief minister of the particular state, he will lose the seat also. What happened in Arunachal Pradesh in 2016? What happened to Uttarakhand? The Supreme Court has created a history by reinstating 2 chief ministers in 2016. 2 chief ministers were reinstated. Never happened. Chief Justice of India said, now the time has come to put the needle back in the clock. Put the needle back in the clock. Never happened, perhaps, in any democratic country. Never happened. And the chief ministers have to swear in again because they were illegally removed. And then what happens to the governors? Nothing. Of course, one governor is sacked. Arunachal Pradesh governor is sacked. Sacked, literally sacked. I think he goes down in the history of governors as one governor who is removed by the President of India. There is no removal provision in Constitution of India for the governor. There is no removal. It says 5 years. 5 years also is not a fixed term. They say 5 years and then say at the pleasure of the president. And what kind of a pleasure president have in this democracy, in Indian democracy? Nothing. Nothing is his pleasure. Even an IAS officer cannot continue based on the pleasure doctrine. He will continue based on his merits. He cannot be sacked because of some other reasons, not because of the pleasure of the president. So in a democracy, in a constitutional governance, there is no space for pleasure of the president or pleasure of the prime minister. First point I would like to point out, because Constitution doesn't prescribe any methodology for the selection and appointment of the governor, and it is very difficult to prescribe certain characteristic necessities, requirements to be appointed as governor. There is absolutely arbitrary decision is the only way. Arbitrary appointment is the only source of appointment of governors. You tell me, in any position in this country, any position, can you such a position in such a great position like formal head of a state, how can you imagine a person to be appointed in an arbitrary manner? And who is appointing? President is appointing. On whose advice? Prime Minister's advice. Now let us see how these 2 persons are appointed. Prime Minister has to take the trouble of convincing the voters and getting the strength beyond 275 MPs. Then only he will become Prime Minister. Good, bad, fake news, good news, wrong information, misleading information, whatever it is, that you leave it aside for the time being. No, he takes all the trouble to get his party elected, gets elected, becomes leader of the party and becomes prime minister. He has some kind of responsibility, though sometimes we criticize that he is not fully discharging his responsibility. We can still say that he is still responsible. Look at the president. In fact, the electoral college of president is broader than the electoral college of the prime minister. If Lok Sabha MPs elect him, he will be elected. Very easy. After elections are done and results are out, to manage a few hundreds of MPs is easy to become prime minister. Now look at the president. President has to be elected by the Lok Sabha MPs, Rajya Sabha MPs, MLCs and MLAs of entire country. Such a big electoral college. And what is the net result? He doesn't have any powers. And those powers he has, he will not exercise. Depending on so many factors. Now, the president can be impeached. There is no way of removal of president except by impeachment. And what about governor? At the drop of hat, he can be removed. I have 2 problems with the governor. One, appointment, not a transparent, not a non-arbitrary appointment of governor. And the removal. Suppose he is doing good job, but central government doesn't like it. He can be removed. And I have a problem with removal also. And all of a sudden, overnight, he will be removed. I know one governor, I don't want to name it because it's a public platform. One governor, all of a sudden removed after 7 or 8 years of governorship. And he doesn't know where to go. There was no time available for him to go out of the Raj Bhavan. There was no time available for him. And removal is equally a problem. Removal is similarly arbitrary. So what kind of a power that you're giving to with regard to governor? And that governor, now, let us see how the governors behave. I need not tell you, you have hundreds of examples and you have recent examples in your own state. I can't give you any more better, interesting examples like that. I cannot. Recently in Andhra Pradesh, my friend Srinivas Rao knows, Andhra Pradesh, the election commissioner was removed and replaced by another election commissioner. It was a big tussle. The case went up to Supreme Court and comes back with the order of reinstatement of the election commission. The governor doesn't bother to sign. Simply he signs. And then nobody understands why he is signing and what he is signing. The constitutional expertise, constitutional nuances have to be understood by him. Any person who is holding the office of president and governor, as on today, because the highly responsible powers are given, entrusted to these two political offices, they are supposed to be very, very careful. And these are the two officers who take oath to protect the Constitution, preserve the Constitution, preserve. Remember, protection of the Constitution, preserving of the Constitution is an important part. I would like to give an example of imposition of emergency. You know what happened in the emergency and how emergency was imposed. The file goes to President of India in the dead of the night from the Prime Minister's office around 12 o'clock. And he wanted to consult Constitution. I'm very happy that he is so conscious about the existence of the Constitution and he wanted to consult it. But unfortunately, at the dead of hour, that hour of 12 o'clock, Rashtrapati Bhavan did not have Constitution of India on the table of Rashtrapati. What a tragedy. Then what happens? He calls secretary or some very important person, ask him to provide him a copy of the Constitution of India. The library places, various places, bookshelves, so many rooms, so many books, so many monuments, so many mementos. You must have seen the Rashtrapati Bhavan. So Rashtrapati Bhavan is far superior than all kinds of Rajbhavans in our country. Okay. Then meanwhile, the officer of the PMO comes to president and says, sir, it is very urgent matter. Madam is worried. There is a delay. Please don't take much time. Kindly approve what we have sent. And then under the pressure, kind of a pressure, he signs. He signs and the file goes. Emergency is imposed. Then after some time, the Constitution copy was made available to President of India. He doesn't read it because the signature has been already affixed to imposition of emergency. And next day in the morning, he listens to All India Radio like you and me. Do you know why like you and me? Though he signed it, he doesn't have any understanding or realization of the impact of the order what he signed. He did not read press censorship being imposed during emergency. He did not read the effects of MISA. He did not read the possible consequences of emergency. He simply signed it. And then next day morning, after listening to All India Radio Bulletin, he wanted to read the Constitution. He read it. And had he read it before signing the proclamation, he would have not signed the proclamation. Do you know why? The constitutional provisions clearly says, unless it is a cabinet resolution from the Council of Ministers headed by the Prime Minister, emergency cannot be imposed. It's a simple provision. Constitution is good. Constitution has its own safeguards. But what are we doing? What are the persons who are occupying the office are doing? And he regretted next day morning, perhaps, regretted having signed the proclamation. But what can he do? Can he take it back overnight? He would have sent it back yesterday night itself to the President, to the Prime Minister of India, to get it formally correct to affix the signature of the President of India. That is called preservation of the Constitution. That is called understanding the Constitution. It is not protection of Book of Constitution in a lock and key, in a bureau, so that it is not available for the President also. That is not the preservation. And look at the way the President acted. And look at the governors. All 356 misuse cases. You must have seen more than 100 misuse cases of 356. They are because of governor and because of the reports of the governor. Now, I told you how the governor is being appointed and governor is being removed, and how the advice, how the authority to send back the file is sometimes used and sometimes not used. I gave an example of president. And do you know, governor has more powers than the president. Governor has more discretionary powers than the president. A president who is elected by a large, broad electoral college consisting of MLAs, MPs, MLCs, doesn't have more occasions where he can exercise discretionary power. And every time he has to simply affix his signature. Whereas governor appoints chief minister. Governor doesn't appoint the chief minister at the behest of the central government. Unless home minister approves, a chief minister is not appointed. And home minister will indirectly approve. That is the situation. And especially when the ruling party in the center and state are separate, governor can play havoc with the democracy, with the administration, with the verdict of the people. They can easily undermine the verdict of the people. Very, very easy. So a selected governor is more powerful than elected president. Such a wonder in democracy, in a written constitution, I think nowhere we will find. There is no critical analysis of certain provisions like governor. People have criticized, now and then they were talking about. And when N.T. Ramarao became chief minister in 1983, he was trying to organize the National Front, combination of opposition parties, a federation of opposition parties. He was successful to a great extent. And do you know what was his wonderful speech, philosophy? Center is a myth. There is no central government. There is no union government. There is no union at all. It's a myth. The reality is existence of states. Reality is center is combination of territory, a whole sum and substance of territories of states constitutes India. And there is no India without states. And if you ignore states and suppress states through governance, it is not a democracy. Forget about federalism. Federalism is a developed, evolved thought in a constitutional governance and political philosophy. It's an evolved thought. That means you respect the people's verdict at a provincial level also. You respect that the people in provincial level have voted me. So I have to respect his vote in the province. That is the respect that we are supposed to give to the elected governments. If both governments are, I can say, three-tier government, a Sarpanch elected, a chief minister elected, and prime minister elected should have same status. The areas of operation differ. You are a bigger king because your territory is bigger, but powers are the same. Power should be the same. So a Sarpanch should have all the powers that a prime minister can exercise towards the nation with reference to his village. That is the power prescribed under so many provisions of Indian Constitution and amendments, 74th and 75th Amendment. What are we doing? And similar to the chief minister. But chief minister can be simply nipped out. Poaching of MLAs. First, poaching of MLAs. Second, support of speaker. Third, support of governor. Fourth, chief minister is out after defections. This is the modus operandi of the government, the political parties ruling at the Delhi. When the same party was ruling, they were appointing and removing chief ministers by sending slips. Delhi se ek slip aa jayega to the capital of the state, and that slip will decide. What is there in that slip? Nobody knows. Information doesn't slip out. Slip has to come and decide who the chief minister of the state is, if the same party is ruling. And if different parties are ruling at the center and state, what will happen? The home minister will decide the future of the chief minister. What kind of a governance it is? And do you remember? My colleagues from Andhra Pradesh, my friends from senior advocates from Andhra Pradesh know that P.V. Narasimha Rao once ruled India for 5 years as prime minister. Do you know? He could not rule Andhra Pradesh as chief minister for 5 years. He could not rule. People thought he's a failure. And do you know why he could not rule? Because Mrs. Indira Gandhi dismissed her own party's government through 356. It's a history. Her own chief minister is a very, very loyal officer, loyal personality to Indira Gandhi. And he went to Calcutta to get approval for expansion of the cabinet. She says, okay, Raoji, expand kijiye. And this man comes to Hyderabad, expands ministry, and she goes from Calcutta to Delhi and imposes president rule. What kind of federalism we are talking about? Where is the federalism? Is this the way you behave with your own government? Your own government means what? The people have given their faith, their belief, their trust to you to rule at the center and the state. And you are not allowing the state to be ruled by the state rulers. That is also an anti-federal action. Because he belonged to Congress party, he is a loyal soldier of Congress party, he did not protest. Okay, madam, thank you. He left it. And look at what is happening today with reference to governance. I'll give you the example of Ramlal. My friends know Ramlal. Ramlal in 1984 played such a villainous role that simply some people were given MLA dress, uniform, lalchi kurta pajama, एक खंडुआ, उत्तरीयम बोलते हैं, अंगवस्त्रम बोलते perhaps in Kerala, अंगवस्त्रम over it, and then cap. Some of the leaders were wearing caps in 1984 also. So some peons and staff members were given MLA dress and they have put a cap on his head and they were counted as MLAs by the Ramlal, Governor Ramlal. And then government is changed. A person who comes with 2/3 majority out of 294 legislators seats, N.T. Ramarao wins 200 seats, but his government is removed within 9 months, within 10 months. That is the problem with the rulers in center. That is the problem. Whether if it is my government, I will change the chief minister. If it is your government, I will change the governors and governors will change you. This is the mechanism, this is the philosophy. Now we are, as academicians, lawyers, we discuss dynamic politics on the constitutional premise. Where is the connection? Where is the connection? Political decisions decide the constitutional offices, not constitutional mechanism. When you allow political decisions like this to decide constitutional office holders, where is the constitutional protection? Where is the preservation of the constitution? It's a very serious question. And another great curse that India is suffering from is people do not know much about the constitution. It became exclusive intellectual property of lawyers and judges and law persons, of course. It is not correct. I think we have a duty, All India Lawyers Union and other bodies of lawyers in this country have a great duty to tell the people Constitution that doesn't allow such type of governance being appointed. Constitution doesn't allow that such kind of removal of state governments, whether a government is fallen or not. We react like a media. We react like a sensational media. What sensational media will do? If a chief minister is removed by the illegal acts of the governor, they will run media shows, lectures, big debates for 4 or 5 days, and then they forget. We are also doing the same. When something happens, we agitate for some time, and then we coolly forget about the problem. I think that all the problems that you are facing with reference to constitutional governance is because of lack of knowledge of the people about Constitution. After 72 years of Republic, people do not know what exactly the Constitution is. People do not know what are the powers of governor. Nobody knows. And you know, when M.K. Narayanan and Bharatveer Vanchu, these are the two governors in 2013-14. Goa governor was Bharatveer Vanchu and M.K. Narayanan was West Bengal governor. They were all supposed to talk about Augusta Westland deal. Do you remember Augusta Westland deal? a VVIP helicopter deal, the possibility of bribes being taken by the decision makers from the private company. Then CBI wanted to wanted to record the statements of, we don't use interrogation. Interrogation is only with reference to accused. So we wanted to question Governor of West Bengal and Governor of Bharat Veer Vanchu. Do you know what happened? They were stalled. They were not allowed to question these two officers, though they are part and parcel of decision making about Augusta Westland deal. As a witness, they were asking. And government, central government at that point of time, Congress government claimed privilege. Privilege. No, our governor is immune, so governor will not talk to you. Whether Constitution of India offered this kind of governance, this kind of immunity to the governor. Indian constitutional governance is ruined by two things. One is pleasure, doctrine of pleasure, by which governors are appointed, but by which governors are removed. Second is good faith class. Do you know what is a good faith class? In every law, you will have every enactment, all lawyers, you must be knowing it. I should not tell this, but let me explain it because the context has come. It says any act done under the, in good faith by the authorities and personalities under the act shall not be questioned in the court of law. Now, what is good faith, sir? Who will define the good faith? Nowhere good faith is defined. And there is no provision in the same enactment to say that malified act will result in a kind of liability. Nothing. Good faith clause is causing havoc, I can tell you. In every legislation, you have a good faith clause. And even if it is a malified action, not taken in good faith, but done with bad faith, no action. No provision in the law to take any action to impose any liability. No provision at all. And good faith is defined by Indian Penal Code, which says action taken with due care and caution is considered as good faith act. Due care and caution. That means what? You did not even have a malified intention to become liable. If due care and caution is missing in governor's decision or any constitutional office holder's decision, in any authority's decision, in the decision of any civil servant, IAS, IPS officer, it has to be questioned even according to that law. By implication, when the act is proved to be not taken in good faith, why not you take action? Why don't you impose liability? Nobody talks about it. Nobody bothers about it. And I think All India Lawyers Union should take up the issue of good faith clauses. Very serious issue. And do you know the Nagaland killings? How the people are killed in Nagaland? Where is good faith? And even your Armed Forces Special Powers Act contains a good faith clause. And there is another clause, very terrible clause. Do you know what it says? If in the interest of public order, in a disturbed area declared by appropriate authority, the armed forces will have power to the extent of opening fire and taking away the lives. And action taken in good faith cannot be questioned. Look at this. You can kill and we grant you immunity. So Armed Forces Special Powers Act gives a privileged power to the armed forces to kill the people, and they kill the people. 20 persons, innocents, not connected with any activity, killed. Do you have right to life, Mr. Unikrishnan? Do you have right to life in this country? What about right to life of 20 people? 20 people do not have Article 21 protection. And law doesn't give any protection. Law says action taken in good faith, immune. Governor, immune. Governor uses immunity to get sealed from being questioned by CBI in an Augusta Westland deal. And similar thing will happen to Rafael also. Similar things will happen to anything. Mofus also, it must have happened. So if I don't want my officer to speak about a scandal, I can make him governor. He will become governor and he'll get all the immunity and he will not speak. What kind of a misuse of constitutional provision. And look at Uttarakhand, Governor K.K. Pal. Harish Rawat has demonstrated 34 MLAs in his support. 34 MLAs. But Governor says, Governor advances the assembly session and asks him to give decision, and they give decision. Deputy Speaker removes. I think Arunachal Pradesh, and I'm slightly confused with Arunachal Pradesh and Uttarakhand. In these two states, speakers, if speaker is with the state ruling party, they will purchase a deputy speaker. If speaker is available, and they're very happy, if they can get any decision with the speaker. Parliamentary democracy is seriously affected by two offices. One is the office of the governor, and second is office of speaker. Parliamentary democracy is at stake. Is in the crisis, I can tell you. Parliamentary democracy. And now look at the powers of the governor. He can do anything. He has discretionary power in appointment of chief minister. It's a very serious power. He can appoint. Generally, we ask in our constitutional law class a question: can any person be appointed as chief minister? Can any person be appointed as prime minister? Answer is yes, unfortunately. Answer is yes. Governor has complete discretionary power, and even the president has complete discretionary power with reference to appointment of these legislative leaders. And the example is the appointment of Rajiv Gandhi by Jail Singh. By that time, Rajiv Gandhi, I don't know whether he is an MP by the time. And he was not leader of Congress Legislative Party. And there was no time available for the Congress Legislative Party to meet and elect its leader. Their leader, Indira Gandhi, is lying dead, assassinated. In the evening, Jail Singh appoints Rajiv Gandhi as Prime Minister of India. Good or bad, he is a good man, not a Mr. Clean. Oh, sab chhod dijiye. What is your constitutional power? Only when it is disturbed, only when there is a crisis with reference to majority, governor and chief minister, the president has certain powers, not otherwise. Sarkaria Commission talks about it. Punchi Commission talks about it. National Commission for Review of Working of Constitution talks about it. There are umpteen number of recommendations how the governor is expected to behave. People say it's a posh old age home, but sometimes it is not correct because very young persons are being appointed as governors. So it is not old age home. It could be a hostel for young youth hostel also. So will you use Rajbhavans as youth hostels and old age homes? Or is it a rehabilitation center for a retired politician? He should be a statesman. BJP also has several statesmen, but they are not being appointed as governors. And lieutenant governors and administrators, do you know who will be appointed? They will be former officers, former IAS officers. And they can play havoc with IPS officers also, havoc with the elected chief minister. Example is Nawab Jung in Delhi, Kiran Bedi in Pondicherry. So governor's office is such an office which is misused by the political party in power at the center. Uni Krishnan was talking about federalism. Nazar also was mentioning it. Surendranath ji also was worried about federalism. I want the political personalities who are in power to read Article 1. Don't read anything about federalism. Just read Article 1 of Indian Constitution. It says India, that is Bharat, is a union of states. You tell me, where is that you are getting power? What is the source of power of the union? States. What is your territory? Some substance of territory of states is your territory. And what is that you are called? You are not a superior central government. You are a government of union of states. And if you forget that, you are not a government of union of states. If you forget that you are government of union of states, you behave like this only. Chandrachud, Dhananjay Chandrachud, has asked the people, asked the leaders to read Article 1. I'm very happy that he said it. You are a union of states. Please understand. What is the union? Union does not mean unitary. Union means you gain power and strength from different states, from all the states, and you are the union. You become union. And if you are not behaving like a union, and if you behave like a Delhi Sultan, you will become Delhi Sultan government, but you will not become union government. Anybody, whether it is Congress or BJP. And you know how BJP opposed the misuse of 356 article. And you know how it is using 356 article. So this is the problem with the politics, with the policies of ruling party. Somehow to get hold of power in a state, even if it is hostile, even if it doesn't have any power in the state, any MLA in the state, not necessary. With 11 MLAs, with 10 MLAs, with 5 MLAs, I will dream to rule the state. And dream is being realized by the governors. Dream is being realized by the speakers. And luckily, Supreme Court and High Court have responded very spontaneously in Uttarakhand, Arunachal Pradesh cases. Otherwise, it is difficult to be restored. And they are lucky. Those two chief ministers are lucky. Do you know why? There was no COVID. There was no COVID. And if there is COVID, the Supreme Court might have not heard them, their case, and they would have lost it. You know, Bommai should have been reinstated according to Bommai judgment, because it is the removal of Bommai that started the litigation. But by the time 2 elections were held in Karnataka and 2 chief ministers were changed, and it is not proper for the Supreme Court to put Bommai back in the seat of chief minister. So a historic judgment did not result in historic remedy. Whereas that judgment has worked in Arunachal Pradesh, worked in Uttarakhand, first time in the history. I say there are only 2 incidents of restatement of chief ministers, 3 incidents of 3 statements of chief ministers in this country. One is N.T. Ramarao in 1984, and he won only because of people's support and MLA's unity. Gone. Then take the Harish Rawat and that Arunachal Pradesh chief minister. They got reinstated by Supreme Court. The rule of law helped them to rule the state when this central rulers prevented them from ruling it, though the people gave them complete verdict. So it is an atrocity. I tell you, the governor's role in this country is an atrocity on union, is an atrocity on federation. It is terrible. It's a terrible situation, I can tell you. And governor today is extra constitutional authority. I can say he's not a constitutional authority, and he has grown oversized beyond Raj Bhavan. Beyond Raj Bhavan, he became extra constitutional authority and extra democratic authority also, because he is not elected by democratic process. He is not appointed by a person based on a system of selection or a transparency process. I want, see, the people are questioning the Vice Chancellor's appointment. No, I agree with them. Vice Chancellor appointment also should be transparent. You must protect the independence of academic institutions. I agree with that. But I want even Vice Chancellor's appointment should be transparent. Vice Chancellor, this Chancellor is being appointed to this state, especially for this state. Why? Are you consulting? Do you remember the M.N. Venkatachalaya Commission's recommendation? Do you remember? Do you know what he said? If you want to appoint a politician, if you want to appoint a statesman, if you want to appoint a governor, appoint a statesman, number 1. Panchu also said it, Sarkari also said it, and the review commission also said it. And then do you know what is the next point of review commission's recommendation? He says, consult the chief minister. Consult the chief minister and appoint the governor. Anybody doing it? have anybody. In fact, in this present situation, consultation process also is being vitiated, violated by your political machinations, mechanics. In North India, they call it jugaad. That means somehow get the things done. अरे हम जुगाड़ करेंगे, कुछ जुगाड़ करेंगे और जो हम चाहे वो करेंगे, is a statement from North India. That means we'll do something and we'll get our work done. So the jugaad institution, the governor institution became a jugaad institution. So I want this government to fall down. When are you going to pull it out? This is the agenda. And what kind of a provisions we are reading? Like a teacher in a classroom. Yes, I know everybody knows what are the provisions of governor in the Indian Constitution. How does it protect the persons? So these are the things I think I thought of discussing with you. I think I have taken a lot of time. Do you want me to continue for some more time or a few more minutes? Or shall I stop it?
Yes, sir. You can. Please.
Yeah. So
Please.
what I would like to say is when Nawab Jung has disallowed Arvind Kejriwal from functioning. In fact, the Pondicherry Assembly and Delhi Assembly, I'd like to make a mention. The rules and constitutional provisions about these two union territories are violations of the Constitution. Maybe I'm making a very serious statement, but it's fact. All the other people have right to be democratically ruled, but the people living in Pondicherry and people living in Delhi, they are not supposed to be ruled by democratic representatives. That is the sum and substance of constitutional provisions specially made for these union territories. The very word union territory is an inconsistency with the first article, Union of States. Inconsistent. Then second point, today Jammu and Kashmir also became union territory. Split, that Ladakh was split out of it. Ladakh is also union territory. But the Jammu and Kashmir is a union territory with an assembly. Delhi is a union territory with assembly. And Pondicherry is a union territory with assembly. It's a waste of time for convening assembly proceedings and resolving and making laws. Do you know why? Unless administrator or lieutenant governor approves it, unless he sends it to administrator is the home minister, unless it goes to home minister and home minister approves it, your legislative decision doesn't have any value. And Supreme Court very seriously commented that if you don't allow, you are an appointed constitutional office holder and you are not allowing an elected constitutional office holder, how can it be a constitutionally supportable, reasonable exercise of power? That is the point. And one governor, I don't know why he fell down from the blue book, good books of the BJP government in 2016, KK Pal. He has to be removed. He said, I would like to be dismissed. I will not resign. Why did he say that? Maybe he was under instruction to do what he did. And if Supreme Court finds fault with him, maybe the fault is not lying with him and somebody else must have been directing him. It's a common sense understanding. Nowhere it will be written and you will not find proofs for it. And governor has to obey the home minister. And if he doesn't obey, he will be removed. And KK Paul case is one example. Pleasure, doctrine of pleasure. How doctrine of pleasure works. And now, how is it they are using? One more point I would like to say before I conclude. Governor position is being used as allurement to Chief Justices of India. Allurement, inducement, post-retirement inducement. And your state has been the example of having a former Chief Justice of India being governor of a state. Former Chief Justice of India, who administers oath to Prime Minister in the absence of President, who administers oath to President of India if he is newly elected. He has to do a job of subordinate of a home minister. when the Home Minister comes to Thiruvananthapuram and he has to stand with a bouquet to welcome him. And what kind of a fall from the high position of Chief Justice of India to the governor of a state? Totally appointed by discretionary powers of the union government. Totally. And totally removed according to withdrawal of the pleasure. And people want that position. People want that position. People who served as Chief Justice of India want that position. Very, very sorry state of affairs. What is that we are learning from the Constitution? Or what are we doing? They are not ashamed of what is being happened. And somebody becomes Rajya Sabha member. Chief Justice of India. And in my view, it is contempt of court. Contempt of court committed by the judges, former judges. I'm sorry to say that. Very serious thing. And what kind of a belief, what kind of a impression people have about these former Chief Justices when they are holding such positions? Technically speaking, they are fine. Not even a gap between retirement and reappointment. Not even a gap, reasonable gap. So governor position is being used as a political rehabilitation. It has extra constitutional authorities, which was never envisaged by the Constitution, and which is an impediment in federal relations between states and union. It is an obstruction to the first article, which will not allow union of states to function as union of states. Instead of being head of the state, instead of being a respectable head of the state, governor is behaving like a agent of the state. Not this governor or that governor. This is not what is expected of this system. It outlived its relevance, governor's position. I know it is very difficult to realign certain provisions of the Constitution if governor is removed. I know it's very difficult. Some serious overhaul of the Constitution is expected. And if I call for serious overhaul of a Constitution, Chief Minister of Telangana was threatened by a sedition case by a BJP leader because he is asking for change in the Constitution, a total revamping of the Constitution. Anybody can ask for it. It's just a statement, just a demand to rejuvenate and redo the Constitution, which anybody has a right to do. Even Ambedkar did not say that we are permanently binding over all the generations to come with the ideas of generation that existed in 1950. He didn't say that. And he quoted Thomas Jefferson. Do you know what Thomas Jefferson says? Every new generation is a new nation. And that new nation is not supposed to be bound or imprisoned by the ideas of previous generation. And Ambedkar quotes it and approves it completely, saying that if Constituent Assembly has not incorporated this concept of flexibility of amendability of the Constitution of India, we deserve to be blamed. We deserve to be condemned. This is the statement of Ambedkar. So we have to review at least the position of the governor. Some people should ask, and I think today All India Lawyers Union should ask for the implementation of recommendations of Sarkaria Commission, recommendations of Venkatachalaya Commission, recommendations of Punchi Commission. Please do it. That should be our demand. Thank you very much for your kind attention. I have taken a lot of time for your perseverance to listen to me. Thank you so much.
Okay.
Then let us conclude.
Yes.
Conclude.
Yes.
And I invite Advocate K.M. Rashmi for vote of thanks.
Dear all, at this late hour, I am taking few seconds to express our happiness and gratitude to all. First of all, on behalf of All India Lawyers Union High Court Unit, I extend our heartfelt gratitude to Professor M. Sridhar for rendering such an enlightening talk on the subject. I hope all of us have benefited by his thoughts. Thank you so much, sir. Our National General Secretary, Advocate P.V. Surendranath, talked to us on the relevance of the subject. ALU High Court Unit extend our sincere gratitude, sir. Our State Secretary, Advocate CP Pramod, the energy booster of our organization, he could not talk to us today. Still, we extend our gratitude, sir. My sincere thanks to Advocate C.M. Nasser for presiding this webinar. Thanks to Advocate C. Unnikrishnan, our Unit Secretary, for all his efforts to materialize this event. Many senior lawyers from various parts of India are present here. Our national and state leaders are attending this webinar. So I sincerely thank all of you for your participation. I also extend my sincere thanks to all my lawyer friends of High Court and District Court for making this webinar a success. Thank you all. Thank you once again.
Yes, sir. Thank you, Sridhar, sir.
Okay.
It was a
Thank
wonderful
you,
experience.
Unnikrishnan. Thank you.
Yeah, it was a wonderful experience. Thank you.
Okay.